Good morning, everyone, and thanks for joining us here today. My name is Carolina Albernas. I'm Director of Business Development Operations at the Brazil-Canada Chamber of Commerce. And we're here today for another episode of the Brazil-Canada Talks, Data Protection in Brazil, Main Aspects and Latest Developments in partnership with our members, FCR Law. Just a few housekeeping rules. After the presentation, we'll have a Q&A session with the panelists. So if you have any questions, please type them in the Q&A box and we'll answer them after the presentation. And for those not familiar with the BCCC, for 47 years, we've been building relationships between Brazil and Canada, strengthening the bilateral relationship in investment, trade, best practices, and mutual growth and prosperity. Our relationships are private and public, featuring the managing directors and decision makers from small, large, and very large companies and institutions. Our volunteer board of directors has expertise, knowledge, and connections that can only be found by being active players in the Brazil-Canada market. As a membership-based association, we support our members through information networking. So if you wanted to learn more about how the BCCC can support you and your company, please don't hesitate to connect with me after this event. So as mentioned, we're here today with Fleury, Coimbra, and Romberg, FCR Law. They are a dynamic Brazilian law firm advising national and international businesses, entrepreneurs, and investors on almost all aspects of the Brazilian law. So without further ado, I would like to introduce Philippe Jeffrey of Council International Tax Advisor to say a few words and introduce the panel here today. Thank you so much.
Thank you, Carolina. Good morning to everyone that is with us for this presentation. Like Carol mentioned, my name is Philippe Jeffrey. I'm a tax partner at FCR Law, and I am also the responsible for the Canadian desk. I'm originally from Quebec City, and I've been working in Brazil for now almost 20 years. So working and advising a lot of Canadian companies exploring or doing business in Brazil from a tax and legal perspective. Briefly, FCR Law, we are a boutique law firms, very international with the Canadian desk, the expertise. We have a US tax expertise, we have a German desk, and based on this, we can obviously work with our clients in French, English, Portuguese, Spanish, and German. We specialize in tax, in corporate law, and also in labor law, both from the advisory and from the litigation side. So we are, and we have approximately 45 lawyers working with us. I will briefly present my three colleagues that will conduct the presentation for you guys this morning. So first, Renata Armonia. Renata is also a partner at FCR Law, and she's the head of our corporate law department. She specializes in M&A transaction, contracts, infrastructure project, and obviously on data protection in Brazil. Bruno Guillem. Bruno is the head of our innovation, startup, and SME department. He's a tax and corporate law specialist. And Bruno has been following all the recent developments in connections with the data protection law. So he's been advising a lot of companies and startup companies on this matter. And lastly, Natalia Dantas. Natalia is an associate at FCR Law, also specialized in corporate law matters, great expertise in negotiation and drafting of national and international contracts. And also together with Bruno, she's been following and advising clients regarding data protection in Brazil. So I would let them conduct the show, and I hope you have an interesting and good presentation. Thank you again, Carol.
Thank you, Felipe, for the introduction. Here's Bruno speaking. On behalf of FCR Law, I would like to emphasize our thank you to Carolina and BCCC for organizing this webinar. This is a really trending topic in Brazil right now. The data protection legislation is constantly in change nowadays. So I would like to start the presentation today with you by showing you an overview of the legislation. The data protection legislation is called the LGPD. It's a general rule legislation, like very similar to the European legislation, the GDPR, the General Data Protection Regulation. I would like to show you just some topics, the topics we are talking about today, but we are going to talk more specifically and in more detail about each of them later today. So the LGPD, the main objective of the legislation is to protect the fundamental privacy rights of individuals and to assure the protection of personal data. The LGPD is a milestone in the data protection legislation in Brazil. We had some rules about data protection, but they were not they were really specific to certain companies. But nowadays and currently, LGPD is the most broad legislation we have right now. So it's been really a milestone in this aspect. The scope of the legislation applies, the legislation is applicable to individuals and companies engaged in processing personal data in Brazil, or in processing personal data with the purpose of offering goods or services to individuals in Brazil. We'll talk about this later today again. The principles we are also explain, the most important principles applicable to LGPD, but here you can see a short summary of each of them. A very important concept to have about the LGPD is the personal data processing concept. This concept is important to understand, to fully understand the applicability of the legislation. And it means personal data protection, according to the Brazilian legislation, means any activity involving personal data. So you can collect data, you can share data, you can access data, you can erase data, you can modify the data. Any of these activities are under the LGPD, and they are considered data processing. The LGPD provides for certain cases in which the data processing is allowed. If there is any data processing outside these cases, these hypotheses, it will be considered unlawful data processing, and the subsequent penalties and sanctions may apply. To enforce the legislation, the data protection legislation in Brazil, the LGPD has also created the Data Protection National Agency, or ANPD. This body, this public body, will be responsible not only to supervise the compliance with the legislation, but also to provide for certain regulations and to specify certain details about the specific, the technical requirements, and some points and aspects there are not really clear up to this moment. The LGPD is, as the name mentioned itself, is a general legislation. So specific details are to be treated, still to be treated by further regulations provided for by the ANPD. We will also present to you the main data subject rights, and most important, what are the impacts to the data controllers and processors, what they should most care about in regard with this topic. And finally, we will also show the difference between the data controller and processor under the Brazilian legislation, and the corresponding responsibilities they are obliged to be in compliance with the legislation. A really hot topic about the LGPD are the penalties applicable under the legislation, that may be up to a fine up to 2% of annual gross revenue in Brazil, limited to 50 million reais per infraction. Really high figures you have here. Other penalties may include the public disclosure of the infraction, which may lead to a reputational risk to the companies involved in the breach. And it may also be linked to block or exclusion of personal data. Such penalty is really important for companies engaged whose core business is linked to the data processing, because they could be not operational really quickly. Another point that is really complex and really confused at this time is the date in which the LGPD will enter into force in Brazil. Nowadays, in a short answer would be the legislation will enter into force in September 2020, but this date is still to be confirmed. We will talk to you about each of the stages that which we have about this topic. But another point to emphasize and to highlight is that the administrative penalties, so the fines, the public disclosure, and the block or exclusion applied by the ANPD would be applicable only as from August 2021. So we have a time frame from the applicability of the legislation itself and the administrative penalties. But we talk about this later on. So the first topic we talk about today is the application scope of the LGPD. So who is subject to the new legislation? It's important to emphasize that the LGPD is applicable to both individuals and legal entities engaged in personal data processing, to the extent that such data processing is carried out in Brazil, that the data processing is linked to goods or services offered to individuals in Brazil. And now, and here I mean individuals in Brazil, located physically in Brazil. They doesn't have to be Brazilian nationals. They don't have to be Brazilian. They have to be in Brazil. And the third hypothesis is that when the data processing linked to personal data collected in Brazil. In any of these cases, the legislation, the LGPD, will apply. There are certain exceptions to the application of the legislation. So LGPD will not apply if the data processing is carried out exclusively for certain purposes, such as academic research, public security, national defense, among others. And in addition, the personal data from international sources may also be excluded from the LGPD scope if such data is not shared with data process agents in Brazil, to the extent that the source country provides an adequate level of protection to personal data. We still don't have a really the concept of an adequate level of protection. This should be regulated further by the ANPD. So now I would like to ask to Natalia, who will talk about the data processing agents. Thank you.
Good morning to everyone. Natalia speaking. I would like to talk about a little bit of data processing agents. The Brazilian General Data Protection, the law, the LGPD, has similar definitions to those given by the European legislation, especially when it comes to data processing agents. It is very important to clarify the difference of each of the data processing agents considered by the Brazilian law as controller and processor, to determine the obligations and responsibilities of each one of them. This evaluation and definition can be very simple or extremely hard task due to the dynamic of the treatment operations that usually involve the controller and the processor. Let's talk a little bit of the controller activities. It can be a natural person or a legal entity, public or private, who makes all decisions regarding the processing of the personal data, determines the purposes of processing personal data, evaluates the framework of the legal basis of treatment, can be held directly responsible in case of violations of the Brazilian law. And also, it is up to the controller to ensure compliance of the data subject's rights. Joint controller, it is possible to have that. And what defines whether this is possible is the analysis of the treatment activity. Regarding the processor, it also can be a natural person or a legal entity, public or private. And basically it carries out the processing of personal data according to the controller's instruction. So the processor, he can tell what to do with the treatment of the data. He has to obey the orders of the controller. And for this reason, the processor can be held jointly liable for violating the Brazilian law eventually. Just a reminder that the processor, as I just said, it must carry out the treatment according to the instructions presented by the controller. So if the processor uses the same data for another purpose, for example, the processor will be considered by the legislation the controller with the responsibilities related to that position. So it's very important to have that clear in mind. As a national authority may request from the controller an impact report on the protection of personal data, when the treatment is based on its legitimate interest, or when involves treatment of sensitive data, it is the obligation of both data processing agents to keep a record of the personal data, data processing operations they carry out. And just a brief explanation about the impact report. It is a documentation in which the controller describes the processes of processing personal data that might put the data subject a fundamental right at risk. So this documentation must contain a description of the types of data and collected, methodology used for the collection and security of information, and analysis of the controller on the measures that can be implemented to minimize risks. Also, the report allows the risk assessment of the treatment activity before it's actually carried out in order to mitigate all the risks. And another fundamental fact is to mention that the national authority must always observe trade and industrial secrets. Just let me, oh, thanks. Another important figure in the LGPD is the DPO, the Data Protection Officer, which is a person in charge according to the Brazilian law, and it is appointed by the controller and processor to act as a communication channel between the controller, the data subject, and the national authority. The DPO's identity and contact information should be released clearly and straightforward. And the DPO's activity consists of accept complaints and communications from data subject, provide clarifications and take action, receive communications from the national authority and take action when necessary. Also guide the entities, employees, and contractors about the practice to be taken in relation to the protection of personal data, and perform the other duties determined by the controller and or established in the complementary rules. The law does not require that the DPO must be employed by the controller or operated, and it is possible to outsource this function, for example, as a DPO as a service. If the DPO carries out another activity in the company, it's very important to verify that there is no conflict of interest of the DPO to perform that function. Now I'm going to talk a little bit about the principles. Bruno already listed all of them, but we're going to just explain a few of them that we consider more important. So the first one is the transparency. The information shall be clear and accurate to the data subject. what data is collected, and what is the and what it will be used for. What's the purpose for that collection, for example. Another principle is the purpose. The data collection and processing must have legitimate purpose for that, and it must be informed to the data subject before any treatment. So as we're going to talk a little bit more about the consent, and so the purpose is very important to be clear to the owner of the data information. Necessity. The collection must be strictly necessary data. That is, the collection of extra data shall not occur if it will not be used. So it's a risk to collect any information that it's not necessary for the purpose of the data processing operation. And the other one is the security. Use of technical measures and able to protect the personal data. There are other principles brought by the legislation, the Brazilian legislation, for example, data quality, prevention, free access, adequacy, non-discrimination, and responsabilization and accountability. Now I think Renata is gonna continue.
Hello, good morning to everyone. I saw some clients in the list of attendees, some friends. Thank you very much for attending this meeting. Thank you, Natalia and Bruno and Philip, Carolina. So, continue to our explanation. We have a few disclosure here. Before go to the slide. When we are talking about civil law, usually everything is allowed, but what's forbidden. So, I mean, you can do everything unless it's forbidden by law. Talking about data processing, that's not true. The data processing is only allowed in the following situations that they are very easy to understand. Let's go through quickly over all of them because it's give you the scenario about what are for whom we are giving this meeting, for whom we are giving these advices, these legal advices. So data processing is only allowed in the following cases. In the case of consent of the owner, we mean that if people agree to share data with you, it's allowed to data processing. So it's advisable to get the consent. The fulfillment of a legal obligation by the controller. So if it's a legal obligation, the controller is authorized. Public administration for implementation of public policies. So it's very understandable. Carrying out of studies by a research body. When it's necessary to perform a contract, so you can process the data. If you're hired to do it, you can freely process the data. Exercise of proper rights in judicial, arbitration, or administrative proceedings. So when you need to defend yourself in a lawsuit, or in an arbitration or administrative lawsuit, you can treat the processing the data. If it's the case to protect the life of the owner or third party, it's a case of life or death, you can process the data without any restriction. Protection of healthy, but in this case only by health professionals. Once this is very sensitive information, we are going to talk about sensitive data also further. When it's necessary to meet the controller's legitimate interest. This is very interesting, and we are going to talk about the legitimate interest of the controller, because all other situation is very understandable and very easy very clear to understand. But the legitimate interest of the controller can be something very different, very special. So that's why we're going to take this topic for further explanation, the next slides. And the last one, for a credit protection. So these are the situations that you can process the data. Thank you, Bruno, please. So what is the legitimate interest? So let's pay attention to this, because the legitimate interest of the controller release the owner's consent of the data processing. This means that the controller of the data processing, can use your information, your data, without your consent if he is using it for a legitimate interest. So to promote her sales, to promote its products. So all of this is legitimate interest of the controller. But this matter is not that simple. Let's understand deeper what is legitimate interest to avoid mistakes. So when you are processing data supported, authorized by the legitimate interest, you have to pay attention to at least two things. The offer you are, like, if you are using the data processing to offer products or to offer services to the owner of the information, to the subject of the information, this offer must benefit the owner and respect their legitimate expectations. So see how it's not precise, but if, for instance, if someone register in your website authorizing you to send newsletters for him about legal matters, so I can offer him some kind of services in legal situations, in legal services, but I cannot offer him any other thing different than this, because this is against the legitimate expectations of the owner. So there is something that you have to be careful when you base your activity, your data processing, on the legitimate interest, on the legitimate interest of the controller. And also, for sure, the data processing must respect fundamental rights and freedoms. So you cannot do anything against the owner privacy or the other fundamental rights, and nothing like this. But this is a general rule also. There are also some conditions for treatment based on legitimate interest. If you didn't take the consent of the owner, you have to use strictly the data necessary for your legitimate interest. I mean, it applies the minimum principle, like you have to use the minimum information necessary to comply with your interest. And you have to keep, as Natalia has also mentioned, the transparency of and document your data processing through reports, because this can be required from you. So the third thing about legitimate interest is burden of the data processing based on legitimate interest. So when you are not taking the consent of the owner, you have to keep the record. Natalia mentioned already, the national authority, the National Data Protection Authority, may request from you the report of impact of personal data protection. And if you don't have it, you may be, they can send you a penalty, and the penalty is not that cheap. So Bruno will mention about the amounts of the penalties and how big, how great they can be. So our advice for you is that when you are processing data based on legitimate interest, you do it only on a residual basis. We mean it's much more safe to get the consent of the owner of the information, the owner of the data, than use it in the legitimate interest. The legitimate interest is something to be used in a residual basis, not as a principal form. Please, Bruno. Thank you. So the next topic is very nice to study also, and very important for you all that working with data processing. We are talking now about sensitive data, information that cannot be used as usual information. So the law considers sensitive information racial or ethnic origin, religious belief, political opinion, membership of a union or organization of religious or philosophical political character, health information, sexual orientation, genetic or biometric data. So all of this information must be used very carefully, and the protections over this data are stronger than regular ones. Mostly because this sensitive data can be, if they are not protected, it can be used in a very regular form, or to discriminate people, or to injure people in any way. So that's why the usage of this data is restricted. So the restriction begins because this information is only possible to be used if there is specific consent. So if you are getting this information from someone, you better to have a term of use or a privacy policy very clear on that, saying that people that are giving you this kind of information are consenting the usage of this information. So the consent here is not a general consent. You have to have a very, very specific consent. And legitimate interest cannot be used in this situation. So only consent. The exceptions to this rule is to comply with legal obligations. Shared, the data can be shared as an exception for implementation of public policies. It can be used for studies by research bodies, regular exercise of rights, including contracts or legal protections, legal proceedings, sorry, life protection and protection of health, only by professionals, prevention of fraud and security of the holder. So these exceptions are, you can justify the existence of these exceptions. It's understandable, but see that they are exceptions. So the rule asks for specific consent. What's forbidden about sensitive data? And data sharing for economic use. So you cannot share with anyone else. And it's also forbidden that you use of sensitive personal data by processors of private healthcare plans. And they because they can use this data processing for risk selection when they are contracting. So if you have the information that I have such disease or some disease that the treatment is expensive, if this private healthcare plans has access to this information, they can refuse my proposal for this or something like that. Or even if they already have this kind of selection, but they have this kind of, the law here in Brazil already allows them to have a background from you. But the worst that it can be, they have to stay with him paying for a period without using the plan, but they cannot refuse you. So if they have access to the data without your consent, they can refuse you for nothing. So that's why they are trying to avoid to open this kind of information for this use. Okay, Bruno. Now Bruno is going to continue. Thank you.
Thank you, Renata. So moving on, another interesting aspect of the LGPD is that the legislation sets forth some cases in which the data processing shall be terminated. So once the purpose of data processing is reached, or the data is no longer necessary or significant to such purpose, the data processing must be terminated. Also, in cases in which there is a time frame linked to the processing. So, for instance, I inform the data subject that I process its data from this date to that date, and once this time frame expires, the data processing must be terminated. Also by request, by both the data subject itself or by the ANPD. The data subject may require the termination by means of the withdrawal of his consent, or any other means, or by simple request in the data controller or the data processor. And the ANPD may request the data process to, or the data controller or the data processor to terminate the data processing in case of breach of the legislation. Upon the termination of data processing, the relevant personal data shall be erased. This means that I cannot keep a database with to which I don't process any of that information. There are some exceptions. The most important are I can keep a database to fulfill legal obligations, for research purposes, to transfer third parties if allowed by LGPD. There are certain cases in which this transfer is allowed, or if the data is anonymized. It's important so to in cases of termination of data processing, if you want to keep such database for statistical purposes, for instance, you should anonymize the data so you can keep it without being in breach of the legislation, and as a result subject to sanctions and penalties, the applicable ones. So now let's talk about the rights of the data subjects. There is the LGPD provides for a long list of rights aiming to provide the data subject with wide control over their personal data. The main rights linked to the legislation is the access to the data, the rectification, the exclusion, data portability, confirmation, and consent withdrawal. The rights, it's important to emphasize that they may be exercised free of charge by the data subject, but not only by them, but also by public entities engaged in consumer protection activities, like we have here in Brazil, PROCON. This means that such entities may act in name on behalf of this data subject and require and exercise the rights of these subjects. So the main point linked to the rights of data subjects. As a controller or a processor of personal data in Brazil, what should I most care about? The confirmation of existence and access to personal data shall be provided to the requesting data subject. This shall be made immediately after the request by means of a simplified report with basic information. So controller and processors must implement automatic systems that provides to data subjects such report upon request immediately, and up to 15 days as of the request. The data subject may also require a full report containing many other information, such as data sources, the process criteria, the processing purposes, among other records. And it's important again to highlight that ANPD shall also regulate such rules and provides for exceptions and companies that may not be subject to these rules, especially in case of this immediately reports that may require certain level of technology to be implemented in websites and other systems.
In regards of the international transfer of personal data, known in the European legislation as transfers of personal data to third countries or international organizations or cross-border processing, the Brazilian law adopt some characteristics of that chapter of the GDPR, establishing a list of hypotheses for the international transfer to countries or international organization in the cases provided in Article 33 of the Brazilian legislation, which briefly are destination countries with a degree of protection appropriate to the Brazilian law, accessed by the national authority when the data subject has provided specific and highlighted consent for the transfer, with prior information on the international character of the transaction, clearly distinguishing it from other purposes. And also when the controller offers and proves guarantees of compliance with the principles, the rights of the data subject, and the data protection regime provided in Brazilian law, for example, specific contractual clauses for a given transfer, standard contractual clauses, global corporate standards, and stamps or seals, certificates, and codes of conduct regularly issued. When the transfer results in a commitment made in an international cooperation agreement, it's also a hypothesis. When the transfer is necessary for international legal cooperation between public intelligence, investigation, and prosecution bodies in accordance with the instrument of international law, and when authorized by the national authority, and so on. It's very important to say that the national authority will have a very important role in the fiscalization of the transfer of international data. So it probably will have a regularization or a regularization of the national authority to take care of that. Also, for the international transfer, the national authority will take into account some factors, such as the legislation in force in the destination country, the nature of the data that will be transferred, and it should be observed the principles of protection of personal data and the data subject rights provided in the Brazilian law. So now I think it's Bruno or Renata to continue.
Hi, that's me. Thank you, Natalia. So now we are going to talk a little bit about security incident. If something goes wrong and some information leak, what you should do, what the law says that you should do. So the controller, as soon as possible, as soon as he knows about any security incident, it should inform national authority and also the data owner, the data subject about the occurrence of such incident. So it's very important to move quickly in this situation. So what you have to inform to the authorities. The description of the nature of the affected personal data, if it's sensitive data, if it's regular data, what kind of financial information, what was about the data that it was took by someone, information about the owners, the subject, the data subject, the owners of the information about technical security measures to protect the data. So if you have time to do it, you have already to inform the authorities what you have done to to decrease the damages. The risks related to the incident. If you have any delay to inform, you have to also communicate the reasons about the delay. And you also have to, if you already have time, you have to inform what measures, what plan you make to reverse or mitigate the damages, the effectivity of the damages. So all this information must be sent to the national authority, and as soon as possible, because all this, as fast as you move, they're going to be more, they're gonna benefit you about if they have to give you a fine or to dosage the penalties, you will be benefit if you move faster. So for this, you have to have plans, internal plans to mitigate. So you have to have a disaster plan in your company. So because when if the security incident happens, you have to activate the people in charge to protect the data. You have to activate the plans, the firewalls, or everything that you have hired for this situation. So to have the agility that law requires from you, you have to have already have a very organized plan internally. So after you inform the national authority, what the national authority can do, they can determine a wide dissemination of the fact in the media. So we saw Facebook has many, they have leaked the information, there was a scandal and all the problems they caused to the subscribers and this kind of thing, and the fine was very high because they didn't move as fast as they should and they didn't inform quickly. So they have a huge fine. Measures to reverse or mitigate the effects of the incident. So same thing, you have to they can determine you to invest or to inform everyone what you will do in this situation. So that's the two activities that the national authority can impose to you. So only remembering that that this for penalties proposed, the national authority will consider the technical measures to ensure the protection of the personal data as well as contingency plan. This note here is only to mention that this is for the dosage of the penalty, so they can decrease the fine if you have all this organized internally. Okay, Bruno, please.
Well,
Go
moving on, regarding the good practices and governance policies, the controller and the processors, within the scope of their powers, for the processing of personal data, individually or through association, might formulate rules of good practices and governance policies that establish the conditions of the organization, their operating regime, the procedures, including complaints, security rules, technical standards, specific obligations for the involved parties in the treatment, in the processing data, as educational actions, internal mechanisms for supervising the mitigating risks and other aspects that the processing of personal data. So it's very important to say that the development, implementation, and maintenance of the governance structure in privacy and protection of personal data correspond to one of the main points of any journey of compliance with the Brazilian legislation. And also the national authority will take into account, into consideration, the adoption of the good practice and governance policies as a perimeter to relieve the penalties of eventually in administrative proceedings. So this subject will be further discussed. But at first, the Brazilian law encourages controllers and processors to implement privacy governance programs that briefly demonstrate the controller's commitment to adopt internal process and policies that ensure compliance with standards and good practices regarding the protection of personal data. Have the purpose of establishing a relationship of trust with the owner, the data subject, through transparency action, and that ensures participation mechanisms of the owner directly. Be applicable to entire set of personal data that are under your control, and count on incident response and remediation plans. And finally, be constantly updated based on the information obtained from continuous monitoring and periodic evaluations. So governance rules must be published and updated periodically, and can be recognized and disclosed by the national authorities. I think now it's Bruno again.
Yeah, a matter of great concern to the companies in Brazil right now regarding data protection legislation is the penalties applicable to them, to the companies in breach of the legislation. So what are the administrative sanctions linked to the LGPD? As we previously mentioned, the penalties may involve several levels of sanctions. The first one would be warnings to the companies in breach. This is normally applicable, or I mean, we believe that this would be mostly applicable to first-time offenders, or in case of breaches that are not that substantial. The fines up to 2% of gross revenue of the legal entity of the group or of the conglomerate in Brazil, limited to 50 million reais per infraction. It's important to emphasize that this amount, this limit, is applicable per infraction. So the total amount imposed of fines imposed to a company or to a group may exceed such amount. Daily fines as well in case of a company that's processing data in breach of a certain provisions, legal provisions. The public disclosure of the infractions, this disclosure is normally linked to a reputation risk. So especially to companies whose core business is linked to data processing, or technological companies or software companies. The public disclosure in some cases may be even worse than the fines applicable. You can see this on a daily basis. Just search for the latest breaches and information leaks. So the reputational risks and damages are really high. And the block or exclusion of personal data linked to the infractions. As we previously mentioned as well, this block or this exclusion may impose that may impact the company, so they cannot operate, because if the core business of the company is linked to the personal data and the data is blocked or is erased, the company may just stop to operate. It's important also to highlight that the penalties may be reduced if the offender can prove good faith, adoption of the damage mitigation system and procedures, and implementation of best practice, as Renata and Natalia previously mentioned as well. Another important aspect is that these sanctions we mentioned are the administrative sanctions to be imposed by the ANPD, but LGPD may also be enforced by courts, in Brazilian courts, which may impose compensation for damages underlying unlawful data processing. So this is important because in many cases the damages, the compensation for damages may exceed the fines imposed by the administrative fines and sanctions imposed by the public authorities. So about the ANPD now, the ANPD is the national authority, the agency that will be responsible for orienting the companies and for further regulates the legislation, the data protection regulation in Brazil. So what's the role of the ANPD? It will impose administrative penalties. It will supervise compliance with the legislation, establish further regulations, technical details, and procedures to be implemented. This is a main topic because the LGPD is really open in regarding some aspects of the data protection legislation. So further regulation will be needed to better define some aspects. Also, the ANPD will interpret the data protection legislation and receive complaints about unlawful data processing carried out by companies or individuals. The structure of the ANPD will encompass both public and private representatives. So it will be a public agency, but the board will be composed by representatives from the public sector and the private sector. And the board members are to be selected by the president. They are still not, up to this moment, we don't have any nominations. So very quickly right now, just to finalize our presentation today, we'll talk about the latest developments regarding the LGPD. First of all, you may have heard the latest news about data protection in Brazil and about the application of LGPD. We will have a really quick overview on what happened up to now and if the legislation is applicable right now in Brazil or not. So the first round about the entry into force date of LGPD was the law 13709 is the LGPD. In section 65, it provided that this law shall enter into force after 18 months as from its official publication. Very plain. So we had a timeline A. The official publication was made in August 2018, and after 18 months, so in February 2020, the legislation would enter into force. However, we have round two, an amendment made by law 13853 that modified the section 65. And now we have two items in section 65. The LGPD shall enter into force on December 2018 in respect to the sections involving the creation of the National Data Protection Agency, or the ANPD, and after 24 months now as from its official publication date. So we have two timelines. So the ANPD was created in 2018, and an extension to the applicability term of the LGPD from February 2020 to August 2020. However, we have now round three. The provisional measure 959 amended the LGPD and provided for that the ANPD's provision remains the same. So on December 28, 2018, the ANPD was created, but the remaining sections of LGPD would be applicable only in 2021, on May 2021. So this was the third scenario we had here in Brazil. And I'm saying this just for you to keep in mind, from round two, round three, occurred in a time frame of almost, 6 months. We had this, and now in this period of time, we had also the round 4, law 14/010, that created another item to section 65. It provided that the LGPD shall enter into force. Okay, we have the ANPD created in 2018, but now the administrative penalties we talked about, so warnings, fines up to 2% of gross revenue, and etc., are applicable only in August 2021, and the remaining sections would keep the extended term of May 3rd, 2021. This was the 4. Now we have the final round. The Brazilian Senate analyzed the provisional measure 959 and rejected the section 4, which modified the LGPD. So we go back another to the other scenario. Now we have the ANPD created in 2018. The administrative penalties would be applicable to as from August 2021, and the remaining sections of LGPD would be applicable after 24 months as from its official publication date, which would be August 2020. However, due to some legislative rules, it would be moved to September 2020. So now the current scenario. So is it applicable? The LGPD is applicable in Brazil right now? The short answer is it depends. About the ANPD, these sections are currently in force. So the ANPD is created by law. The administrative penalties would be applicable only as from August 1st, 2021. This is also established. But the remaining sections of LGPD will be enforced only after the president decides about provisional measure 959. The decision itself to accept or reject the provisional measure will not impact the entry into force date of LGPD, but the date of the decision will impact. Once the president decides, the LGPD will come into force. However, we have an alternate ending that may change this whole current scenario. An agreement between the president, the legislative, the Senate, the Chamber of Deputies to postpone the LGPD to January 1st, 2021. This agreement may occur, and by means of another provisional measure, the president may postpone the entry into force of LGPD. So the executive power has time to organize the ANPD and further regulate some details that are still not quite clear in the current legislation. So this is the scenario right now in Brazil. It's really complex and really confusing scenario, and again, very dynamic and subject to change. About the ANPD, it's the latest development we have right now. The ANPD, as we saw, was created by LGPD in December 2018. However, only in August 27, 2020, the administrative structure was defined. So it really extends time frame before the ANPD is duly organized. The ANPD will have important roles. So if the legislation takes effect in 2020 without the ANPD being established, being organized, and further regulated this some aspect of LGPD, we'll still have undefined rules and no administrative enforceability, because an ANPD will not supervise the compliance with the legislation, nor will apply the administrative penalties and sanctions. But as we highlighted before, the courts may already apply the legislation once the LGPD enters into force. I think this concludes our presentation today. We would like to, again, thank you, Carolina and BCCC for, on behalf of FCR Law, for having us and organizing this event. And we remain available to answer any questions that may have arisen. And to further discuss this topic with you, please get in touch, and we can further clarify any topic you may need. Thank you very much.
Okay. Thank you, Bruno. Thank you, Natalia. Thank you, Renata, for these amazing presentations. Very informative. There's a lot of things to process. So we do have a few questions. I know we're kind of like running out of time, but we do have a couple questions. So first one is in terms of like information that you gather from the internet. So if you find an article, if you read an article and then you modify that information to publish in a newsletter prepared by a company, is it allowed to do that? What are the policies in terms of how to handle that kind of information?
Yeah, I think I can answer that. It depends. I mean, a personal data, the concept of personal data, according to the LGPD, is an information that I can link to an individual. So if the information is on the internet and it refers to an individual, it may be treated as personal data, and the LGPD may apply. However, in this case, if you are only modifying any information you find in the internet, but which does not qualify as personal data, the LGPD would not apply. However, other rules and legislation specifically about authors' rights, copyrights, yeah, may apply. So I believe it's not LGPD, under LGPD, right? Renata, if you want to.
Yes, Bruno. Seems like that in this situation, it's more to do with copyrights legislation. Like, it's better if you find an article and reproduce it entirely, it's for sure you have to mention the source. If not, you only make a summary or something like this, I don't think it's necessary to link to the source because you're rewriting. But it depends on the quantity of information that you are copying. It's better to inform. So in this situation, I don't think it's nothing to do with the LGPD legislation. It has to do with copyright legislation. That's for sure.
So I assume that if you just add a link, for example, I mean, we do that all the time. We kind of like, for example, we have some articles that were wrote by you guys, and we do a link that takes you to your website. It's just a compilation of information that should be fine in terms of LGPD and copyright.
Yes, I presume so. If you just give the link, all the information that in the link is already with the author's information. So it's also nice to have a look, especially in the bottom lines, to see if there is any restriction about copyright. But most of them, they don't have any restrictions. And if you send the link, all the information and the data information of the author is also there. So that's nothing wrong to do this.
Perfect, thank you. Another question here, if you can make a comparative between contract and responsibility rules to DPO in Brazil and Canada.
I can answer that. The DPO cannot disobey the instructions of the controller, or the DPO can be held liable for if the disobedience cause harm to the owner or data subject. So the rules between the contract and the responsibility of the DPO in terms of causing damage to them is very similar, I think, in both countries. So, and there are also a possibility of the return action process. For example, if the controller is responsible legally for the actions that the DPO has done and the harm the DPO has done with the data processing, it can the controller can also file a process to the DPO. So I think I don't know if Bruno or Renata wants to complement, but basically I think it's the same between both countries, the responsibilities.
Yeah, just like to add that the DPO rules in Brazil are still to be regulated by the ANPD as well. So right up to now we don't have this level of details about DPO, but certainly the ANPD would say something about this topic futurely.
Yeah, I just mentioned about the legislation, but as Bruno already said, the national authority will in the future probably, bring some rules regarding that subject.
Perfect, thank you. And then, so I have another question too. So for example, if we have some data that is processed, Brazilian data that is stored in a Canadian cloud, what would be the applications for that? Can I storage data in a third-party country, or how would that work?
I can answer that. When you have any doubt about what you can do, what is under the LGPD Brazilian law, you have to go to definition. So this law is very easy to understand. If you look there, what is considered treatment of processing data, what's processing data, in the definition, you have storage there. So if you have collect the data in Brazil, or if you're offering products to Brazilians, or if you pick up the information when people were in Brazil, if you are under these circumstances and you take this information and you're going to storage in another country, you are under the Brazilian law, because this law considers storage, treatment, processing of data. So when you have any doubt, you go to the definition of the legislation to check what if what you are doing is under the definition. So in this situation, you are under the Brazilian legislation.
Perfect, thank you. So there are a couple comments here. I don't know if you want to, if you guys want to comment in terms of, it would be great if the ANPD recognized Canada to have an adequate level of data protection, similar to the data protection adequacy status by the European Commission. And if some customers, just like they have started to do in the EU, still demanding that their data be held locally, but knowing that there was a push to have Canada recognized would provide some comfort. So right now there is not really, is Canada like, how is the relationship between Brazil and Canada data protection system or laws?
Bruno, I believe you can answer this.
Yes, as we mentioned, the Brazilian LGPD is much based on the European regulation, right? So we strongly believe that if the European Union considers a place like Canada to have an adequate level of data protection, security and regulation, we strongly believe that the ANPD may do that as well. I mean, the bases are really similar. And Canada has this legislation and has this regulation, and so it's just an opinion right now. We don't have anything concrete. The ANPD will have to talk about this, but that's my opinion. I don't know if Natalia or Renata have any other thinking.
No, that's it.
That's pretty much it.
Well, so thank you so much, Bruno, Natalia, Renata, and Philippe, for your participation here today, for your time, your availability. This is very informative, and I think that there's a lot of questions that will come afterwards. So if, for the ones watching us, if you guys have any questions regarding the LGPD, please feel free to connect with FCR Law. They'll be very happy to assist you. So I would like to also thank the BCCC annual sponsors, Vale, Votorantim, Cimento, Samara Cement, Landing Mining, and Brookfield for their support. And we hope that you found the information here very fruitful and relevant for your business. So please keep engaging with the BCCC. Follow us on social media. We have a lot of events and webinars happening in the next few weeks on many different sectors. So please follow us. Please go to our website, www.brascanchamber.org, or follow social media to stay tuned with everything that's happening. I hope you all have a great day, stay safe, and I'll see you all very soon. Thank you so much for your participation here today. Thank you.
Thank you too.
Thank you. Bye-bye.